The U visa was established to offer protection to victims of crimes who assist law enforcement, particularly those vulnerable to exploitation due to their immigration status. It was not written with constraints limiting it only to traditional street-level crimes or local perpetrators. The qualifying criminal activities listed under federal regulation are broad and inclusive, encompassing a wide range of psychological and coercive harms. This opens the legal door for interpreting some federal actions, especially those by ICE or DHS contractors, as falling within the statute's protective intent. When federal agents use threats, coercion, or unconstitutional restraint tactics on immigrants, localities are not compelled to defer judgment. Rather, they retain the power to recognize harm inflicted within their borders, regardless of the perpetrator's federal badge. The U visa in this context becomes more than an immigration benefit. It is a localized legal recognition of criminal victimhood and a procedural conduit to justice. Certification becomes a statement. The state will not allow abuse to go unnamed just because its origin is federal. One of the strongest elements of this framework is the assertion that criminal conduct is criminal conduct, regardless of who commits it. Federal agents do not carry immunity from state criminal codes, especially when operating outside constitutionally authorized boundaries. Actions such as detaining someone without lawful process, using threats of deportation to extract information, or coercing silence through fear, can all fall under state definitions of unlawful restraint, extortion, or obstruction of justice. Local authorities have both the jurisdiction and the duty to respond to such harms. When ICE engages in abusive or retaliatory acts, local law enforcement and prosecutors can, and arguably must, consider whether these acts constitute qualifying crimes. This is not political defiance, it is legal fidelity. By doing so, local agencies are upholding the integrity of their own criminal justice systems and refusing to allow federal overreach to corrupt the standards by which victimization is recognized. While the U visa certification process is discretionary, that discretion must not be misunderstood as a justification for paralysis. It was created not to allow local law enforcement to abdicate responsibility, but to empower them to make human-centered judgments about victimization, particularly among those most vulnerable to exploitation and silence. When a credible allegation arises, especially one fitting squarely within the statute's expansive list of qualifying crimes, local agencies have both the authority and a public duty to act. Declining to certify in cases where harm is evident, simply because the harm originated from federal actors, becomes a form of selective blindness that undermines the core purpose of the statute. More importantly, certification has legal and practical consequences even before the visa itself is granted. Once a U visa petition is filed with a valid certification, the applicant gains de facto protection against removal, even in the absence of formal immigration status. While USCIS retains exclusive authority to approve or deny the petition, it also grants deferred action or stays of removal for applicants whose cases are under review. In practice, this means that ICE is barred from detaining or deporting someone who has a pending U visa petition with a properly executed law enforcement certification. That pending status can also unlock eligibility for a work permit under certain conditions. Thus, the issuance of a certification is not a symbolic gesture, it is a shield. It immediately places the applicant under the umbrella of federal protection, insulating them from the very types of retaliatory enforcement that may have led to their victimization in the first place. It sends a message not just to USCIS, but to DHS. This person has been harmed in our jurisdiction, has cooperated with our justice system, and is now under the watch of our laws. Local certifying agencies are not circumventing immigration enforcement. They are creating lawful conditions under which the federal government is required to pause, review, and protect. In that sense, the act of certification is a form of civil refuge. It empowers communities under siege to stabilize themselves through lawful process, to create time and space for justice to take shape, and to protect residents from further trauma while their claim is heard. To fail to issue a certification in such a moment is not simply to decline a discretionary act. It is to abandon a protective function codified in federal law for exactly these moments of systemic vulnerability. In contexts where communities are under sustained assault from aggressive immigration enforcement, legal actors and local governments have few tools to push back in a manner both lawful and effective. The U-Visa certification process becomes one such tool. By documenting trauma, substantiating fear, and recognizing how threats or coercion function within power imbalances, these certifications flip the narrative. Victims are not silent or paralyzed. They are witnesses, participants in justice, and claimants of lawful protection. This strategy leverages existing law, not by distorting it, but by applying it precisely where its moral and protective purpose is most clear. Threats to call ICE, unlawful arrests, and coercive tactics all become visible within a legal framework that recognizes psychological harm and systemic abuse as real injuries. These are not speculative claims. They are rooted in specific legal categories designed to acknowledge exactly this kind of vulnerability. The certification process becomes a channel for lawful counteraction in an environment otherwise marked by fear. At its heart, this framework is a reaffirmation of federalism, not a rejection of it. Local and state governments are not vassals of federal authority. They are co-sovereigns with independent constitutional mandates. When federal actors violate state laws, localities are within their rights to name those violations for what they are. Silence in the face of such conduct is not neutrality, it is complicity. Certification in this light is not rebellion but accountability. There is a broader constitutional implication here as well. If localities surrender the ability to recognize harm when the perpetrator is federal, they risk conceding their core purpose, the protection of the people within their jurisdiction. The U-Visa certification process is one small but potent way to reclaim that responsibility. It reasserts the power of local governance to define and respond to crime, even when federal actions are the source. Far from undermining the law, this framework activates its fullest democratic potential. Of course, such actions will not be without consequence. Federal agencies may retaliate politically or operationally, and there may be legal challenges. But those risks do not undermine the legality of the approach. They are the price of using lawful mechanisms in defense of the vulnerable. To yield to fear of reprisal would be to abandon the very people the legal system was designed to protect. In the face of escalating enforcement abuses and constitutional violations, local governments must decide whether they will participate in the silencing or stand with those seeking lawful recourse. Certification in these circumstances is not a loophole or an indulgence. It is a declaration of values, and of the law's enduring capacity to name injustice, no matter the uniform worn by its author. What this framework proposes is neither insubordination nor subversion. It is a principled legal response to unlawful harm. The U-Visa statute was designed to offer protection where fear and violence silence voices and perpetuate abuse. That silence becomes more deafening when the abuse originates from federal agencies themselves. Local law enforcement, by choosing to acknowledge these harms, is not undermining the system. They are embodying its highest aspirations. Certification becomes an act of integrity, a refusal to allow the machinery of federal enforcement to escape the bounds of legal and moral accountability. It is not merely an immigration issue, it is a democratic one. In a time when rights are under siege, the willingness of local actors to stand in the breach may be one of the last remaining defenses of constitutional order. The U-Visa, used in this way, is not a loophole. It is a line in the sand.